Ready to proceed, Your Honor.
You may.
Could you please tell us who you are, but not your name? Are you the victim in this case?
Yes, I'm the victim.
Thank you. With your permission?
Yes.
Okay. After the assault that happened to me at 14 years old, I've struggled in many ways, some obvious and some not as obvious. In the short time after the attack, I struggled with feeling extremely violated and dirty. I'd shower and scrub myself raw while sobbing because I felt like he was still on me somehow. The overwhelming feelings of shame, hurt, and pain I felt were unimaginable. I couldn't stop the thoughts flooding in my head. It was hard to breathe. I tried to escape with sleep, and it haunted my dreams. I couldn't escape the unmanageable amount of emotions. I had switched bedrooms to be closer to my dad, to feel safer. I did everything I could to feel safer in my own home. I struggled to understand my own emotions, questioning why me, who would want to harm me in this way, what did I do to deserve this, and who was it? These questions alone can drive anybody mentally insane, let alone a 14-year-old girl. These questions never went away and sometimes only got stronger. A common issue that isn't often discussed is that some assault victims become hypersexual, which happened to me months later. It becomes dangerous. You can't say no to people because you're afraid of them using force. The fear of force in sexual situations caused me to go into shock. Long term, the attack caused me to spend years trying to come up with a story that made sense. I've always believed there was another person involved, and I'll probably always believe that. I have seen the person who I believed had part in it, and it put me into a panic. I quit a job after noticing he was hired at my place of employment, worried about being followed or harmed. I've struggled with making friends because the only information I had about my attacker was his skin tone, glasses, and that he was thinner with a more fit appearance, and it led me to feel anxious around anybody who resembled him, as I never knew who my attacker was. As a single mom, living alone with 2 little girls, I always felt scared when it got dark. For years, I'd wake up with nightmares and be startled by smaller noises, creaks on the headboard, rustling in the fan, my pets moving around, and my neighbor moving, or making any sort of noise that I can't see. The sound sent me into a panic. I'd call the police, hide under my blanket, convince someone was breaking in. The cops would come search my home, reassure me, and I wouldn't be able to sleep the rest of the night. This happened multiple times a month for at least 2 to 3 years. To this day, I still get nervous around men drinking beer because it reminds me of the smell of my attacker's breath as he breathed on me when I cried with his hand over my mouth. My self-worth plummeted, leading me to become hypersexual, neglect safe sex practices. I put myself in harmful situations, believing that was all I deserved, and felt unworthy of someone treating me with genuine care. I've been diagnosed with night terrors and PTSD from the attack. I've gone to therapy on a weekly basis. I experienced night terrors and flashbacks triggered by reminders of that night. I also began sleep talking, almost full conversations, swearing and being upset is what people around me have told me. Over the past 2 years, I've missed months of work due to the overwhelming stress and triggers exacerbating my PTSD during the court process. When I received the call that there was a match, it had been almost 8 full years since the attack. I was on my break at work and broke down, sobbing, hyperventilating for almost 45 minutes. I worked at my child's school at the time, and so when I went in, I hugged my child when I was very upset still. I tried to push through the day, and I was allowed to spend the last few hours of work with her class because I was in no shape to work. I struggled to trust anyone to this day because I don't believe you truly ever know a person. Almost 10 years have passed. I still suffer from night terrors and flashbacks. When major triggers occur, I feel nervous about not knowing who a delivery driver is, and I avoid retrieving my items until they've left. Uber, DoorDash, any sort of delivery service. When someone knocks on my door unexpectedly, I get anxious and sometimes panic, as the people I know, I don't expect them to knock. I expect them to come in. Often peeking through windows and checking my Ring cameras before ever going towards the door. I have kids who have friends, and even though I know during the day that there's a knock, it's probably just a friend asking to play, I still get nervous and have to make sure before opening the door. My kids are affected as well, as my anxiety and fears are still very overwhelming. I no longer trust anybody. My kids don't get to have sleepovers at anyone's homes who I'm not personally close with, as I'm unable to protect them in someone else's home. I'm unable to guarantee their safety. Every night I triple check that all the doors and windows are locked and shut, sometimes getting up again to make sure. After all this time, it still affects me in many ways and will forever. Something the defendant will never understand the feeling of. That being said, I believe he should be sentenced to the highest extent, as it's been shown to this day there's no remorse or for any of the pain and suffering that was caused. Thanks for hearing my voice and bringing me justice.
Mr. Thomas, before I sentence you, you have the right to make a statement, although you are not obligated to do that. Do you wish to make a statement before I sentence you?
I do.
You may.
I believe that I've been wrongly convicted. I don't understand how this person can sit up here and say that I did something, but when it came to trial, she did not recognize me. Well, that's when she was reading that letter just a couple of moments ago. She just said that the person that she suspected of this went to her job also and worked there. I also believe that this county should do their investigations properly on both sides, the victim or whoever's been prosecuted. I'm going to lose my life to something I did not do. If this truly did happen to her, there should be justice, I believe. But justice for the right person. That's all I have to say.
All right. Mr. Thomas, there was a finding of guilt on all 4 counts pursuant to Minnesota Statute 609.04. This court is prohibited from entering convictions on both greater counts and included counts so long as they were both from the same criminal act. The conduct proven in this matter constitutes one criminal act. Accordingly, as to count 1, first-degree criminal sexual conduct, judgment of conviction is entered. Pursuant to Minnesota Statute 609.04, Subdivision 1, Parents 1 and 4, counts 2, 3, and 4 are included offenses within count 1. Accordingly, the finding of guilt has been accepted, but no further adjudication will be entered on those 3 counts. The first issue regarding sentencing pertains to the amount of credit to which you are entitled. Pursuant to Minnesota Rule of Criminal Procedure 27.03, sub 4, parent B, this court must give credit for the number of days spent in custody in connection with the offense or behavioral incident being sentenced. You bear the burden as the defendant of establishing entitlement to credit for the time spent in custody during criminal proceedings. In determining the amount of jail credit to be awarded, appellate courts have directed trial courts to avoid 4 particular concerns. Those being, number 1, the de facto conversion of a concurrent sentence into a consecutive sentence. Number 2, making persons serve longer sentences for not posting bail. Number 3, relying upon irrelevant factors to calculate credit, such as trial dates. And number 4, allowing credit to be impacted by prosecutor manipulation. Several cases include a cursory reference to these 4 concerns, but to understand how each concern may apply to a particular set of facts, it is insufficient to merely cite to the list of concerns. Rather, each concern must be analyzed separately with reference to case law that applies individually to each specific concern. concern. Regarding the first concern, which is de facto consecutive sentences, this issue of de facto consecutive sentences applies when defendants have a previous sentence that is stayed and the defendant is later held and sentenced on a new charge. In those circumstances, if the previous sentence is revoked, the court must include credit for time spent held on the new charges. Those circumstances do not apply to today's sentence. To be clear, if Mr. Thomas has some other previous state sentence that is later executed, he will presumably be entitled to credit for time served after that previous sentence, even if the time served was only in connection with the matter currently before the court. But this does not impact whether today's sentence creates a de facto consecutive sentence, as was considered in the Dulski case and the Weber case, both Minnesota Supreme Court cases. As to the second factor regarding defendants who do not post bail, you will receive credit for the entire time that you have spent in custody since you were arrested on this matter. There's no doubt about that. That credit is still less than the presumed sentence under the guidelines, and as a result, defendants' inability to post bail in this matter will not make the final sentence any longer. Unlike the issue addressed by the Minnesota Supreme Court in State v. Hott, where the district court refused to give credit on a jail sentence where the credit was accumulated after the arrest and before sentencing, here this court will award all credit accumulated between the time of arrest and today's sentencing hearing. Regarding the third factor or concern, and that is reliance upon irrelevant factors such as trial dates, the most illustrative case regarding using irrelevant factors to calculate credit is the Arden matter, a Minnesota Supreme Court case from 1988. In Arden, the Court of Appeals awarded credit to a defendant for time served between the trial date and sentencing, and denied credit for time that the defendant was incarcerated between the date of the complaint up to the trial date. The Minnesota Supreme Court rejected that notion, indicating that credit should not be calculated based upon the trial date because such a circumstance constituted an irrelevant factor for determining credit. This court is not using the trial date to determine how much credit should be awarded, and thus the concern of relying on irrelevant factors is not present here. Regarding the fourth factor, that is prosecutor manipulation, State v. Foley, that is the Minnesota Supreme Court case from 1989, is the quintessential case that addresses when credit should be awarded to cure inequities relating to matters that are subject to manipulation by the prosecutor. The Foley case stands as a shameful embarrassment for any prosecutor who understands its contents. Specifically, in Foley, the defendant was in jail for a DWI court file. The prosecutor at the same time knew that there was probable cause to charge the defendant in a separate case, a separate incident with criminal sexual conduct. But the prosecutor, instead of charging the matter, secretly communicated with the jail that no charges would be filed unless the defendant posted bail on his DWI case. The prosecutor even directed the jail to not tell the defendant of the criminal sexual conduct allegations unless and until the defendant posted bail on the DWI case. In the Foley case, the prosecutor secretly told the jail that if the defendant successfully posted bail on the DWI case, instead of releasing the defendant, that the jail should then hold the defendant and contact the prosecutor, who would then file new charges. In Foley, the defendant never posted bail, but was later acquitted of the DWI, and then he was in the process of being released. At that time, the prosecutor charged the defendant with criminal sexual conduct, eliminating the defendant's ability to be released. Under these manipulative and embarrassing circumstances, the Minnesota Supreme Court rightfully gave the defendant credit on the criminal sexual conduct charge going back to when probable cause existed to charge the defendant with criminal sexual conduct. Suffice it to say that the record in this case is nothing like folly. There is no indication that the investigation was complete until DNA testing was received in July of 2023. There is no indication that the prosecutor or law enforcement even had a possible suspect until June 8th of 2022. That was when the initial, albeit inadmissible, DNA database match indicated that follow-up testing may match defendant's DNA to the DNA gathered from the SART evaluation. There is zero indication in this case that there was delay that was intentionally engaged in or with any intent to prejudice the defendant. In short, this case is not folly. This court concludes that credit should go back to when the state had probable cause to charge the defendant. Pursuant to Minnesota Rule of Criminal Procedure 11.04 Subdivision 1 Parent C, and with reference to Rule 18.05 Sub 1, probable cause must be demonstrated by evidence that would be admissible at trial. There are exceptions, but none of those exceptions allows for probable cause to be determined based upon a test that will not be admissible at trial. Thus, probable cause existed here no earlier than July 10th, 2023, when the admissible BCA DNA test was completed, indicating a match between defendant and the DNA obtained during the SART evaluation. Time served between the date of offense, that being September 18, 2015, and July 10th of 2023 will not be awarded in this matter. The amount of time served since July 10th of 2023, with reference to an arrest date of what this court understands as July 27th of 2023, is approximately 677 days, but I will rely on probation to recalculate and confirm or deny that amount. This is the credit to which defendant is entitled, and the sentence shall reflect the same. Mr. Schlosser, do you have your independent calculation of credit between July 10th, 2023 and today?
I have 694, Your Honor.
According to the rule of lenity, unless there's an objection, I will use the probation's higher number. Can you repeat the number, Mr. Schlosser?
694 as of today.
Defendant's criminal history score is calculated at 5 points in the worksheet. 1.5 of those points are attributable to 3 fifth-degree controlled substance offenses. Defendant cites to Strobel, the Minnesota Supreme Court case from 2019, which stands for the proposition that you must assess whether a prior is a felony or a gross misdemeanor based upon the offense definition that was in place for the prior at the time of the offense. Now, there is significant dispute about what these cases stand for, but in this court's review, I will simply note this: the Minnesota Supreme Court case in Strobel affirmed the Court of Appeals. The Court of Appeals expressly held that we therefore hold that a prior fifth-degree controlled substance possession offense may not be classified as a felony when calculating a criminal history score to be used in sentencing a crime that occurred after the effective date of the DSRA amendments, if the prior offense would qualify as a gross misdemeanor under subdivision 4A of the DSRA. Meaning, this court views the Court of Appeals holding as providing complete clarity of what issue was before the court. The Minnesota Supreme Court affirmed. As a result, this court concludes that the prior fifth-degree controlled substances were felonies at the time of the offense, September 18th, 2015, and they are rightfully included in the calculation of the applicable criminal history score. The correct criminal history score is therefore 5. You are hereby sentenced to 360 months commitment to the Commissioner of Corrections, of which you will serve 2/3 custody and 1/3 unsupervised release, barring any disciplinary infractions which may result and you leading up to the entire 360 months incarcerated.
He's gonna charge me back.
Credit for time served,
Makes sense.
quit talking. I'm sentencing you. The credit for time served is 694.
I'll go back.
Your commitment to put him down in that chair.
I'm done.
Your commitment to the correctioner shall be followed by a 10-year period of conditional release. Restitution is left open for 30 days. You are required to register as a predatory offender for the duration of your life. And if you fail to do so, information about you could be made public that would not otherwise be published, and your failure to register may be punished as a crime. No costs, fines, or public defender fees assessed. We are adjourned.